there are many times where the youth moves through the system, particularly because I think there's a recognition when the offenses are either not that serious or very serious that diversion or family involvement, community involvement isn't necessarily going to add anything, or could interfere with some of the procedural processes that protect innocent until proven guilty, that kind of thing, that mean that we don't have diversion or sentencing circles or community justice in all situations, but they try to use it quite a bit in order to separate out and save the formal court processes only for the ones that really need it. One of the potential sentences under the Youth Criminal Justice Act would be to be sentenced to probation. Under Canadian law, both for adults and for youth, probation is considered a rehabilitative sentence. So it's not considered punishment. It's considered something that's supposed to be helpful to the offender. Obviously, there's an element of probation which has conditions to it that requires the person to be reporting and to go to meetings with their probation officer and to do certain things that the probation officer says that some people might feel or at minimum they're an obligation, and they could feel that there's like a punitive component to having to have that obligation, but that's not how the Canadian law views probation. It really views it as a tool to try to help reintegrate the person into society and to correct, future potential offending behavior. So for a young person, there are sort of two ways that you can be, or two kinds of probation that you can be sentenced to. You can be sentenced to probation like as a standalone thing without any other component. Probation can also be part of the end of some other kind of sentence. So if you are if you did serve some time in custody and you were sentenced to some time in custody, there could also be a probationary period afterwards. But the two different kinds, there's sort of regular probation, and then there's something called IISP probation, which is intensive supervision support probation, and that's a kind of probation that is uniquely available to youth. And so youth probation is administered by youth probation officers. So they're specialized probation officers just for youth that are different than adult probation officers, and they receive specialized training within the ministry to be youth probation officers. And then sort of even more specialized would be the individual supervision and support probation officers, and that's a very intensive kind of probation where you'd be meeting very regularly with the probation officer and receiving, quite a lot of services through probation, and that can be a way within Canadian law to get access to some of those services without a long waiting list. There's sort of prioritization for youth that are under an intensive supervision and support probation to move up the waiting list and to have some of these services provided to them. And that includes, working with social workers and having social workers as part of that intensive supervision and support probation. You can have a social worker through the child welfare system, completely separate and apart from the youth criminal justice system, and you can have them both at the same time. The child protection, or child welfare and child protection run separately from the Youth Criminal Justice Act, and they, one of the things I work on is trying to get them sometimes to coordinate together, because sometimes they operate a little bit too distinct from each other, but there are sort of separate mandates that exist. So a youth that happens to get youth criminal justice charges may already be working with a social worker from the child welfare system. If they're not, if they don't have any involvement with a social worker and they get youth criminal justice charges, one of one of the ways to get connected to a social worker through the Youth Criminal Justice Act is through the IISP probation. But even without being sentenced to that very specialized and intensive kind of probation, you can get connected to a social worker through, for example, mental health diversion. They'll have social workers and counseling connections and that kind of thing, and potentially, through bringing together different service providers in the youth criminal justice process, that also might bring a social worker into the mix, whether it's through something called a Section 19 conference, basically when the judge brings a bunch of people together, through your school. There are various ways in which, through the diversion process, through the regular court process, that might be something that gets suggested even without being sort of sentenced to that, or there being some kind of formal order of a social worker. There's also something called Section 34 assessments. That's another tool with quite a lot of privacy protections built into that. The point of that is to get a psychoeducational assessment of the young person, to try to understand whether there are any mental health issues that are contributing to the situation, and also to see if there are any learning disabilities in education that might be going on that could explain either what's going on or how it could be dealt with, or in a way also to be a rehabilitative tool. So when you're thinking about, okay, well, we're trying to look at it in a holistic way, understanding where a youth might be struggling in school, if you're able to get an assessment that points to some ways, some of the barriers, then recommends some solutions to that, the young person might no longer be so frustrated, and they might get on a better path and down the line be a productive member of society where they don't feel like engaging in offending behavior. And so that's kind of another approach that's within the mandate of looking at it in a holistic way, multifactored approach to the root causes of the offending behavior. So lastly, what are the common risk factors for reoffending? So working backwards from that kind of example, when those things are not addressed, right? When you have youth that are in traumatizing environments where their social, economic, emotional needs are not being met, they're likely to be in fight or flight mode and survival mode, to be very reactionary. And that's where, a lot of the offenses you find, those kind of risks for harm arise often in youth from that kind of environment. So I think the biggest risk factor for reoffending is if none of those needs or issues are worked on or addressed through the process. So in youth criminal justice in Canada, a youth would never be sentenced to an indefinite sentence, like one that lasts forever. There would never be any kind of capital punishment. So the young person, they're going to be back out in society at some point, and within Youth Criminal Justice Act, sooner rather than later. And so if none of those emotional, social, economic factors are addressed, then the youth is probably going to stay on the same path that they're on. But I think one of the strengths of the Canadian system is that there's a lot of effort that is made to address those different factors when they're in the youth criminal justice system. And I've had just many clients who, when they're young people, they have quite a lot of very serious charges, and by the end of their interaction through the Youth Criminal Justice Act, they are on a good path. They're a working, productive, educated member of society who's not engaging in any more criminal activity, and that's strictly due to the approach that's taken and really looking at the whole of the youth and the whole of the system and addressing it that way rather than it being, strictly punishment, and being more focused on rehabilitation and giving young people a chance to make mistakes and not have it follow them for the rest of their lives.